now as pressed as anybody in the section, 100 pages behind in torts and falling off the pace in each of the other courses. That workload did not, however, keep me from going to see Ralph Nader when he came to speak at the law school on Tuesday night. I am a Nader admirer. I take him for a zealot, but I also think he is a person of uncommon imagination, somebody who sees beyond the flack and baloney most of us buy in thinking about social institutions. The institutions Nader was going to speak about that evening were Harvard Law School and legal education in general. Nader is an HLS grad, but he is hardly an enamored alumnus by the administration. He's quoted as describing the law school as a place where students were taught the freedom to roam in their cages. In my funk, I was eager to hear his criticisms. I was ready to believe that there was more causing my bleak feelings than my own neuroses. Then he describes the speech, and he ends with this quote from Ralph. "Ask yourself," Nader said near the end, "shouldn't bright people who think of themselves as self-confident, qualified, shouldn't they be the ones to take on these impossible problems? You don't have to lend your power to those huge drug companies that don't care about the public they deal with, or the big law firms that defend them. They can get other people to do that. If you say, I will be a narrow professional, finding pleasure where I can, then you are demeaning yourself." Thoreau writes, "I left Nader's speech feeling high. He's been convincing, and he left me feeling better than I had for a while that I was becoming an attorney." He drove home that feeling full of hot purpose and temporarily out of his law school-induced depression. I hope today has the same effect on you. The reason I brought Ralph here today is because there's two reasons people don't fight for justice. One is they don't know the facts, they haven't seen it for themselves. Ralph's the king of fighting against empirical starvation. The other is even if they know what's wrong, which all of us should know by now what's wrong with this country and what we need to fight for, they don't believe that they can do it. They don't believe that they can make a difference as a lawyer. And Ralph Nader's life is a testament that you can make a difference as a lawyer. As a 3L, he wrote a paper that went on to become unsafe at any speed, that went on to save millions of lives. If you're a 3L here today, you can write a paper too, just like Ralph did, that can go on to save lives. His career has led to the Freedom of Information Act, the Clean Air Act, the Clean Water Act, mine safely legislation, the banning of smoking on airplanes, the popularization of the word whistleblower. The bell when trucks back up is called the Nader bell, beep, 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 you know that? The Occupational Health and Safety Act. He's a member of the class of '58. He's been fighting to change this law school for half a century. And might I add, he's one of the earliest hosts of Saturday Night Live. He convinced Sesame Street to have a song about consumer advocacy for children. He's America's chief public citizen and a hero of mine. Without further ado, Mr. Ralph Nader.
That's great. You really set it up for me, Pete. Let's consider this a workshop, although it's only 1 hour, because I understand you all have to beat it at 1 o'clock. And thank you for coming, even though you're not being offered pizza. This is quite a pleasurable change from a few years ago, and that seemed to be a requirement. I'm going to go at a relatively fast pace. This is not a single issue workshop. I want to try to get you more fact prepared. You know, you come from the top of your class and often from colleges and universities, but like most of us, we come to Harvard Law School factually unprepared. We have no idea about how power twists law, the interstices of corporate machinations, the maturation of the corporate state, the evolution of illegal empire ratified by a lot of members of our bar to justify what's going on, and so on. So to do this, we need a frame of reference called history. And I want to just describe what happened when I got here. In 1955, it was a year after Brown versus Board of Education. It was in the middle of the 50s. McCarthy was phasing out. Excuse me. And what was most interesting is the single-minded focus of a totally male law school class. We had 15 women out of 550, and there was no women allowed in a law school until 1950. And remember, we had professors and deans and they were the best and the brightest in the country. And if you didn't believe them, all you had to do was ask them. And yet they found ways to rationalize no minorities, very few women. This was a male-dominated class. And 11 states at that time prohibited women from serving on juries, including Maryland. That wasn't even discussed when I wrote an article about that in the Harvard Law Record. The record, to me, saved my legal education, because the Harvard Law Record at that time came out 24 times a year, and it went to 10,000 alumni. At the time, it was the second largest legal publication circulation after the American Bar Association. And it dealt with the law writ large. It dealt with reality. It dealt with the twisting of political and powerful forces to keep the law from being utilized by the majority of the people in this country. And it dealt with all the things we didn't study in class. And basically, law school then was a system of controlled neuroses. You didn't have stress relief events like you have now. You know, I just saw it in the elevator. It was a place of very high tension. I remember I was walking past Harkness Commons once about midnight, and I saw the pages from a casebook all over the ground. And I looked up, and there was a light on the top floor. Everyone else was asleep. And I picked up the pages from the casebook, and it was Hadley versus Baxendale. And I said, geez, someone must have substituted that for slashing his wrists. It just exploded, and he tore the book apart. And was I concerned about that person? Oh, no. You know what came to my mind? Why did he pick Huxley versus Baxendale, whatever it is? In other words, this is a great case. What is he doing, tearing it out of the book? Should have tore something else out of the book. That's when I realized that the law school was getting to me, that it was compressing my frame of reference. Now, here's what the law school was then compared to now, and you should ask yourself what changed it. What changed it were street demonstrations, civil rights, anti-war. The students were participating. They came back. They demanded, here's what they demanded: more women, more African Americans, more Hispanics. They demanded that there be clinics. You have about 24 clinics now. We had none. We had just legal aid, and you had to have a high score in your grades to get on to legal aid. So there were no clinics. There was a big debate as to whether the law school should even have a clinic. Is that in the Harvard tradition? We had a situation where we studied in corporations class heavily the Delaware Corporation. They were all chartered in Delaware. And it was like in the middle of the year before anybody raised their hand and said, Professor, why are all these cases Delaware Corporation? This is a tiny little state, you know. They want to practice in New York and Wall Street. And the answer came back, well, Delaware has a very intense and deep history of corporate litigation and corporate chartering, and that's where the big companies go to charter. So that's where the litigation is. Nobody said that this is a permissive jurisdiction that was a race to the bottom, pulling other state chartering commissions with it, but never as extreme, so that the Delaware state budget was about 30% based on these fees, and it was very permissive for offices and directors to ignore shareholder rights, investor rights, be secretive, and so on. I mean, it was a time, we called it a corporate Reno at the time, and as I said once, General Motors is chartered in Delaware. General Motors could buy Delaware in a weekend if DuPont was willing to sell it. But you see, that reality of what it did to corporate law was never discussed. The detailed intricacies of corporate law were parsed, but the overall political reality that the birth certificate of the corporation is not investors. The birth certificate is the state, and the state can take away and condition and completely change the relationship of the corporation to its constituents, whether it's consumers, workers, investors, you name it. It was never discussed. And so I began saying, what's going on here? In my torts class, we had cases where we had driver against driver combat? Who was negligent? Assumed the risk? Who contributed the negligence? It was before comparative negligence. And we never talked about the highway and the vehicle in the highway vehicle driver matrix. So we never, other than McPherson versus Buick, thank you, Justice Cardozo, we never studied the role of automotive construction and design in terms of standards of care and standards of negligence or outright criminal crime and not recalling defective cars. The contracts course was even more bizarre. Here is the contracts course where we were really in the cul-de-sac, consideration, meeting of the minds, etc. And nobody began raising the question that the world of contracts was non-negotiable unless you were in business or government or a labor union. They were standard form contracts, and they are now much, much worse. And so we never studied that there was no meeting of the minds, that the idea of consent judicially imposed was total nonsense. It was fiction. We were studying myths. We were studying fictions. Freedom of contracts, one of the great pillars of our democracy. Freedom to go to court for a wrongful injury case, one of the great pillars of our democracy. These are private uses of law. These are legal rights that are invocable by the victims. They don't have to ask permission. They can try to negotiate a better contract, or they can go to court against GM or Exxon or whatever, Pfizer, before a trial by jury. And over the years, they have been shredded to a point where they're dangling by a string. Not more than 1% of wrongfully injured people use the tort system, and the freedom of contracts completely destroyed. It's so destroyed, it's part of the culture. For example, you all are contract peons. We all are. We all sign on a dotted line or click on. You don't read it. You can't even get some of these contracts. The Airbnb contracts like this thick, even if you read it, you couldn't understand it. If you read it and you understood it, you couldn't do anything about it because you consented to everything, right? Wrong. It's a complete fiction. So we've lost all of this. And where are the professors? Where is the curriculum over a period of 50 years? I think the worst example is that thousands of Harvard Law students came here burdened by loans, Sallie Mae loans and other loans, a horrific one-sided contract of adhesion with a horrific interest rate and all kinds of trapdoors after the students graduated that they never knew about. We had some of the smartest contract professors here, and not one of them stood up and made a big issue out of it. Not one of them did an Elizabeth Warren event to shake up the world of contracts, to protect their own students. You see the estrangement between theory and reality? You see what educational ideology is all about? You ask yourself, does Harvard Law School have an ideology? Well, as they say in Kansas, you betcha. But do you ever see it? Is it or just the tip of the iceberg? Well, we didn't see it then. We didn't see the issues of contracts and torts. They had a joke at the time. They actually made fun of it. They said, here at Harvard Law School, in the morning, we distort the law of contracts, and in the afternoon, we contract the law of torts. Ha, ha, ha. Trying to acculturate us, with a legal joke. Little did we know, that's exactly what happened over the next 50 years. That they weren't preparing us. This was a law firm, this was a law school that basically was a finishing school for Wall Street firms and Bay Street firms and State Street firms and Washington corporate law firms. That's what the students aspired to. I remember once I was in a course that dealt with taxes. Tyler Bridges is here. When he was a young man, he worked for us. He's a journalist. I sent him up to Harvard to sit in on a tax course and then write it up for our publication, People and Taxes. Well, I'm sitting there listening to this, scratching my head. There's nothing about taxes for the people, nothing about. It's all very intricate stuff. It's considered real hoi polloi, really challenging stuff. And walking out with a professor, I said to him, Professor, is there any course on food in the law? And he went like this, food? And you know, you were in awe of professors then. It's not like today. And so I said, you know, the stuff we eat. And he composed himself and he looked up, stroked his chin. He said, well, I suppose there's not a course on law and food because the section of food law hasn't developed to a sufficiently intricate level that would present a sufficient intellectual challenge for our students. I mean, I'm not even going to comment on that, other than to say you now have a food policy and law section here at Harvard that comes to grips with how the law has been totally abused in terms of protecting the health and safety of the food, its relation to the environment, the issue of hunger, and on and on. So how did all this change? It changed because street action, demonstrations, litigation, picketing, sit-ins, teach-ins, students came back and they demanded change. Some of the faculty picked it up, and then they went to the administration, and belatedly there was a response. You now have a different law school. Now the question to ask yourself is, what is it that you're missing now that my law school friends missed then in terms of injustice, in terms of risk level, in terms of the subordination of law and the rule of law to the rule of power, the rule of empire, the rule of corporate law firm strategies? What is it now that you're not being exposed to? And this is why this report is so important by Peter and the Harvard Law Record. Because this is a publication to start thinking about the law school, about your careers, about the leverage this law school can have with law schools all over the country, 200 of them. This is about what the feedstock is that's coming out of this law school. What level of morality, what level of ethics, what level of one's own significance? Do they realize that the law's singular purpose is to advance justice in all its manifestations and difficulties? It is not to grease the wheels for the top 1% that in this world control 50% of the wealth, or the top 10% that control 80% of the wealth, and the top 1/10 of the 1% even more concentrated. And this, Peter and his friends here are going to have breakout sessions in the coming weeks for each one of these sections that were discussed. The question is the law school going to respond to this? Is the law school administration going to ignore criticism the way it has over the years, at least in terms of not contending with it publicly in debates? Is Dean Manning going to discuss this publicly with you? He's not here today. It's funny, every time I come here, the law school deans are somewhere else. Are the faculty going to discuss some of this in the courses? What's so sacrosanct about the lesson plan? We have to have empirical infusions here. You have to have normative infusions here. Law severed from morality is an instrument of oppression. Think of the landlord. We had a course at law school called landlord-tenant. We almost never got to the tenant. What, you didn't have Harvard Law School graduates going out representing tenants. There's no money in that. You represented big landlords, big property owners, big deals. And so whole generations of Harvard Law came out without knowing the real stuff about torts and contracts and investor rights and pension rights and civil liberties. There were always a few who broke the mold. And hallelujah to them, because they became the great leaders for justice, fighting the death penalty, fighting for women's rights, LGBT rights, all that. There are exceptions, but the exceptions were not bred here. The exceptions were because the way they were raised, or the experience they had before they came to the law school, or some extracurricular activity. They weren't bred in the formal curriculum. So let's look at today. We have a situation where, how many of you know what Harvard Law School's endowment is? What is it? Tell me. What is it?
Yeah, like around 32 billion.
32 what?
32 billion.
No. No, the endowment is between 1 and 2 billion. Yeah. Okay, so let's say Harvard Law School is dedicated to justice. You heard Peter talk about the mission statement. I mean, it's right there. As they say, you could hoist Harvard Law School by its own petard, right? That's their mission statement, to have leaders in justice for a better society, just to paraphrase it. All right, so why doesn't the endowment, especially how it can leverage itself with very wealthy people, because Harvard Law School gets their calls returned, start public interest law institutions all over the country so that they have positions for you. They want you to be good and be for law reform and access to justice and get the poor having tools of power to defend themselves. Well, where are the jobs? And there aren't more than about 1,000 public interest law jobs in the entire country, and that's a liberal estimate. Where are the jobs? Why don't they set up with Yale and Michigan and Bolt Hall and others? Why don't they set up a consortium where they build the institutions of the law which become the leverage to build the institutions of democracy and open it up, tackle the inequalities of wealth and income by tackling inequalities of power, which is fundamental and a predicate to inequalities of wealth and income. Now, this isn't a leap of imagination. But most students will go through Harvard Law School and never look at the endowment. They'll never look at Harvard Law School's responsibility. We say, listen, law schools are academic institutions. You can't involve them in action all the time. Cognitive dissonance will arise. Well, do you know how much Harvard Law School's done for corporations? International section on taxation when I was there. You have the foundation, what's the name of it? Olin Foundation. You have mass of the curriculum is built around corporate law and corporate power and corporate perpetration and corporate defense. You have the great sessions that come here and they embrace the head of Goldman Sachs. They support the national security state. They make sure the law review is irrelevant, however technical and perfect it is in terms of fonts. It's like that. They make sure that you pay a price if you spend too much time on extracurricular law and justice activities because you might not get the grades. Luckily, they have diminished the loan burden. They have this nice, innovative public service venture fund, and it's to their credit they're doing that, but students put a lot of pressure on them and some progressive alumni to get that underway. So here we have a situation where you want to get together with each other and you want to say, think the unthinkable, ask the impermissible question. What's the estimate of your own significance? What are you going to look back on 60 years from now? It's like 18,000 days or so, less than 3,000 weeks. Did last week go fast? You can't believe how fast it'll go. It's a blink of the eyelid, especially as you grow older. It's been said the slowest year in people's lives were when they're 15 waiting to get their license at 16. And you have to ask yourself, are you going to become a lucrative cog in a corporate wheel? Plenty of wheels, plenty of opportunities. Do you really want to be part of the perpetrator class? Do you really want to be part of the class that covers up massive deaths and injuries, penury, fraud, in an enveloped corporate crime wave? You think I'm exaggerating? It's an understatement. Just read Business Week, read the Wall Street Journal. They'll give you a glimmer of systemic corporate crime. The Corporate Crime Reporter in Washington, D.C. How many of you have ever heard of it? CorporateCrimeReporter.org. The editor is right here. He's overwhelmed with corporate crime. Now, I can see a professor saying, now, what do you mean by corporate crime? There aren't any corporate criminals violating the auto safety law. And I say, you're right, professor, because they got it out before the law was passed in 1966. They excised it. So for premeditated, willful, and deliberate violation of motor vehicle safety standards that have led to death and injury and destruction, there is no criminal penalty. Therefore, there can't be any corporate criminals in the auto industry. Didn't you know that, Ralph? And this is where the word comes in. It's called criminogenic behavior. It's behavior based on the precepts of criminal behavior when the criminal law was common law, before it was codified. And when you add criminogenic behavior and fill in the gaps in federal and state legislation that have excised the criminal penalty out for corporations, not for individuals, lesser people, when that happens, you have this corporate crime wave that becomes institutionalized where we don't even see it. When we're ripped off, we don't even say, this is a crime. I didn't consent to this. When you bounce a check for $35 penalty, does it ever occur to you that you didn't consent to this? Oh, yes, you did. It's in the fine print backing up the little deposit card when you opened an account. Somewhere in the bank vault. Are we slaves of this kind of corporate-induced legal fiction? Let me tell you what happens when a frame of reference gets liberated. How many of you have heard of Judge Richard Posner? Famous judge, circuit court out of Chicago. Graduated here like 62. He wrote a book every year. Unbelievably prolific. He's written 3,500 legal opinions. He's one of the founders of the Chicago School of Law and Economics, whereby everything is measured by money, literally, marginal utilities, money. He's the person who taught a course while he was a judge at University of Chicago Law School, and he came in at the beginning, and he went like this. He wrote the word justice on the blackboard, and then he said to the students, you see that word? And they said, yes, Judge. He said, that's the last time I ever want to hear that word in my class. Now watch this. Watch what's happened when a brilliant mind breaks out of a self-conceived ideology. Basically, the monetized view of justice. Here it is. Quote, about 6 months ago, quote, Judge Posner said, quote, I awoke from a slumber of 35 years, end quote. He suddenly realized, he said, that people without lawyers are mistreated by the legal system, and he wanted to do something about it. The imminent reason for his retirement was less abstract. He had been concerned with the plight of litigants who represented themselves in civil cases, often filing handwritten appeals. Their grievances were real, he said, but the legal system was treating them impatiently, dismissing their cases over technical matters. Judge Posner said he hoped to work with groups concerned with prisoner rights, with a law school clinic, and with law firms to bring attention and aid to people too poor to afford lawyers. On the phone, Judge Posner said that his opinion in a case where he reinstated a lawsuit from a prisoner, Michael Davis, that had been dismissed on technical grounds, saying, quote, Davis needs help, needs it bad, needs a lawyer desperately, he wrote. He said to the New York Times reporter, quote, the basic thing is that most judges regard these people as kind of trash, not worth the time of a federal judge, end quote. Let that sink in. What happened to his legal education here? Why wasn't he aware of the obvious? Does it really take microscopic perspicacity that most people can't afford our profession's fees? Does it take a tour around the country to realize that the law is used more as an instrument of oppression, fear, dread, self-censorship, exclusion, and disrespect than it is for what it should be, as Senator Daniel Webster once said, the great work of human beings on earth? This is an amazing story, and you can get it from Adam Liptak, September 11, 2017, New York Times. Now, let's take a look at, very briefly, the categories we have to study more so we can work on them more, so we can link knowledge to action. There's an old Chinese proverb that says, to know and not to do is not to know. That was a tremendous product of Harvard Law School. The professors know, and they don't get you motivated to do sufficiently, other than people like John Hanson and a handful of enlightened professors here who look at the big picture. Okay, now, I have recommended that the law school curriculum split in two parts. One part is called the Harvard Law School curriculum, and you study the existing law, and you analyze it, and try to understand it, and see what the judges have interpreted, and what the legislative history would be, and what the ambiguities are, etc. Then there'd be a curriculum called Harvard Lawlessness Curriculum. And it would study lawlessness, systemic lawlessness. The lawlessness of presidents who start criminal wars of aggression, killing over a million Iraqi people, and millions injured and sick, with an entire society blown apart based on lies and deceptions by Bush and Cheney. Unconstitutional, violating federal laws, violating the UN Charter, violating the Geneva Convention. Not a ripple here at Harvard Law School. One of the head apologists, John Brennan, came here in 2011, the security anti-terrorist advisor in the White House to Obama. All the brass came out, and they gave him a standing ovation. Look at that speech. It's online on the Harvard Law video. It was a nonstop assertion that everything they've done abroad was legal and constitutional. A couple of years later, it all started to spill out, didn't it? Assassinations, killings, violating sovereignties, blowing up villages, blowing up weddings, so sorry terrorism, violating all the rules. Not a ripple here. Nothing out of the Harvard Law School. Law Review. What do they exist for? To burnish their vitae? Lawlessness. The law of contracts. Utterly lawless. These are legislative dictates by private power. Anybody get angry? It doesn't matter how much you know if you don't have fire in your belly. You got to have both. You got to have moral indignation to fire up your legal expertise. That doesn't mean you go nuts, you know. You fly off the handle, start cussing, and so forth. It does mean that no social justice movement ever was on cognitive information alone. It was on the feeling of injustice. And if you don't have a sense of cultivated injustice, you cannot have a sense of justice. Think about that. You cannot have a sense of justice without a cultivated sense of injustice, which is what law school curriculum should be all about, and which is, I assume, a lot of the clinics are all about. Lawlessness in terms of the commons. You know, I never studied here at the law school anything about what the people own. And guess what? The people own the greatest wealth in the country. They own the public lands, a third of America, and as much offshore. They own trillions of dollars of pension funds as workers. They own the public airwaves that the radio and TV stations are given free with no limitation on who they can keep off television and radio. All the major industries in our country were built on taxpayer-funded research and development out of Washington, NASA, Department of Defense, National Institutes of Health. If we own, why don't we have reasonable control of what we own? Because the intelligentsia at universities never made a popular issue out of it. They never educated people about it. And the politicians, of course, are not going to pick it up because the money's on the other side. Just think what we could do with a complete democratization of the commons in terms of people's welfare, respect for posterity, etc. The other areas, just very quickly, Sandra J. O'Connor is devoting her retirement now to trying to do something about no access to justice by a majority of people. She says it has a real effect on their lives. They get sick and stay sicker. They get evicted from their homes. They can't get a job that even put food on the table. This is a conservative justice. She's seen the light too. When you expose yourselves to the reality on the ground that is so horribly abstracted at the university graduate school level. There's also the issue well, let me just compress it tremendously. 250,000 people die in this country every year from preventable problems in hospitals. That's 5,000 a week. That was the minimum figure given by the study out of Johns Hopkins University School of Medicine in May 2016, a one-day story. 5,000 a week. How many day stories come from 9/11? How many trillions of dollars in overreaction? How much civil liberties have been crushed from 9/11? 3,100 people. Deliberate massacre. How about this? 5,000 a week. Criminal negligence, hospital-induced infections that were reduced when they had the doctors and nurses wash their hands more frequently. Things that were neglectful. Does that present a legal challenge? That level of violence is preventable? Of course. Are there any federal standards here? De minimis. Any state standards? De minimis. Harvard School of Public Health estimated years ago 2,000 people a week die from hospital malpractice. A one-day story. Is that a legal challenge? Was there a sudden SOS from the Harvard Law School to the Harvard School of Public Health? Let's get together for an emergency meeting here. It's only 2,000 people a week. How about 60,000 people who die from workplace-related diseases and trauma? I once suggested that Harvard Law School should have 6-week internships where they sprinkle your class with people who come out of the coal mines, people who come out of the textile mills, people who come out of the migrant farm harvest world. So they just mix it up with you, and they start asking you those brilliantly dumb questions that you never asked to bring you down to earth. Just sprinkle, maybe 6, 7 in each class, and then they go back. Maybe you've taught them something, but I'm sure they'll have taught you something. If you can't imagine anything, you can't envision real possibilities. And if you can't envision real possibilities, you've relegated yourself to far lower levels of significance given your stature. You're in the top 1% in terms of income, knowledge, health. What are you going to do with it? That's what you have to keep asking yourself. You know, a simple way to do it is, do you want to be the tribune and strategist for the perpetrator class, or do you want to be the tribune and strategist for the victim class? And the victim class, not just gender and minorities. In many ways, it's all of us. It's the risk of nuclear war. It's the risk of climate change. It's the risk of mutated viruses and bacteria and pandemics around the world. And what are we doing? We're working on the 17th count of some antitrust lawsuit for some corporation in a corporate law canyon for 7 years. I once knew a very brilliant lawyer, and he put his kids through college because he represented a company in New Jersey that was selling Geritol. And the argument was in the ads that it cured tired blood. And the Federal Trade Commission thought it was deceptive and not evidential. And so they went after the company. And he delayed that process for about 10 to 12 years. Can you imagine having grandkids on his knee when he's 80 years old? And he said, "What did you do when you were a lawyer, Granddad?" "Well, you have to know, I represented a company that had a drink for tired blood." I mean, how ridiculous. A diminishment of the human spirit and the human skill and the human intellect. So, just to go through, do you know just 3 blocks from here, there's an applied mathematician. His name is Malcolm Sparrow. He's a professor at Harvard. And he should be at a Harvard Law School forum. Pete's got some great speakers, you got great posters. Fill those seats. Show up. Harvard law students have a hard time, like most law students, just showing up. They're too busy glued to this menace here. This thing, tap dancing the cell phone. Text messages. You're shredding your brain. Throw them aside. Have a week free of the cell phone. I've had students say, I die without the cell phone. All right. So you know what he's documented? You know what he has documented? And it was fortified by a General Accounting Office estimate in the U.S. Congress, 1992. 1/10 of all healthcare expenditures are stolen by computerized billing, fraud, and abuse. You see like in Canada, you don't get these reams of bills and codes, inscrutable entries, etc. It's an invitation to fraud and to criminality. Now, you know how much that is a year? Okay, the defense budget just skyrocketed over $650 billion. This is $350 billion down the drain. Anything in Harvard Law School on that? Harvard Law Review, maybe? Maybe a seminar called Small Accounts? Anything dealing with the lawyers who facilitate these billing frauds? The design firms who design these bills to be full of trickery? The phony bilking of Medicare? That's $60 billion a year, Medicare. Was that part of the health insurance debate? No, didn't exist. Do you know how many dollars bank robbers steal from banks every year? Maybe it's $50 million. But with a pen or with a computer, this is what happens. So just let me end on this note. We could have talked about the criminal injustice system. This is so bad that if you looked at the overall criminal injustice system, from the arrest, the discrimination, the prosecutorial abuse, the poverty, the prisons, the incarceration, if you just looked at it and you were given some sort of infrared glow, and the glow came from where there was criminal justice, you would hardly see it on the screen. But the criminal justice works very good for corporate criminals. They're not prosecuted if they're big guys because they're represented by your predecessors in Simpson Thatcher, Cravath Swain, Covington and Burling, Hale Ropes, Gray, whatever they are now when they merge. That's what's going on. Last point I want to make, and then I want to open it up, is this. It comes down to your own self-respect. It comes down to what is the level of significance do you wish to attain your remarkable talents, intellectual acumen, and that brand name Harvard Law School. It comes down to whether you're going to make excuses for yourself. Oh, I got to pay off the debt. Well, maybe that's less of a debt now. Maybe you can get it loan forgiven. Harvard has one of the best loan forgiveness programs. If you're in public interest law, every year they forgive that portion of the debt. And it comes down to what you want to look back on. When that grandchild asks you, at age 9 or 10, beginning to sense where the world is spinning and devolving and disintegrating, what did you do, Grandma? What did you do, Grandpa, when this was getting underway? It comes down to the extent to which you will build legal institutions of power and perseverance and self-renewal. It comes down to putting the phrase, we the people, in the context of your intellectual and normative ambition for a just society and a just world. The U.S. now is a mighty empire. Every empire devours itself sooner or later. That will happen on your watch. And it won't be just military devourment. It'll be infrastructure devourment. It'll be labor devourment. It'll be income security devourment. It'll be legal rights devourment. we started the first law museum in the world. Can you imagine? What does that say about our profession? The American Museum of Tort Law in Connecticut. We're bringing the law to the people. As an Indian jurist told us from Mumbai, who visited it, you're bringing the law to the people. The people who go through that museum, you can go to tortmuseum.org, are transformed because of the graphics and the accuracy of these legendary cases and the contemporary cases that you study. T.J. Hooper, for example, the Pinto case, the asbestos cases, the cigarette cases. This is what I mean by institutions. So if I haven't put enough on your plate, let me recommend the following. I put this together for people like you if you're not motivated to incur a career of nonstop justice seeking. This is designed to get you angry. So there are excerpts from the Washington Post, Wall Street Journal, New York Times of corporate crime. All kinds, drug companies, oil companies, banks, insurance companies. It starts out saying, stay with this for 3 hours or so and see whether you're ready to break your routine. Routine is the enemy of human creativity. I know it gets you through the day and it gives you a certain reassurance. If you don't bust up your routine, you'll never bust up your tranquility, which is going to be pretty determinative of what you're going to do in life if you allow it to prevail and to predominate. I'll leave you with this outrage. Look at our legal system now. Secret wars, secret courts, secret evidence, surveillance of attorney-client communications by the government, unauditable secret expenditures for quagmire military operations, even redacted judicial decisions. You're reading decisions, West Publishing, that are now redacted. Secret prisons, dismissal of habeas corpus rights, shredding of probable cause, indefinite imprisonment without charges, and massive violation of Fourth Amendment with dragnet snooping. If all those do not generate a crisis of attentiveness and engagement at law schools, we're lost. We're lost. Because these are not episodes. These are embedding themselves into the very fiber of the contamination of criminal and corporate power throughout our legal system, or what's left of it. Thank you very much.
Thank you, everyone. Let's keep it going for Ralph Nader. There's, at 1:10, there's I believe, a corporations class coming in. But we have time for questions before that. Any questions for Ralph for engagement? You can just raise your hand and we'll bring you the mic. Okay, right over there.
Hi. So you talk about the power of the public wealth and public lands and what we share together. But in a generation where we're increasingly spending our time on private servers, where our Constitution is completely eviscerated, what can we do to start to build a new Sherman Act that says we're going to stand up to the huge antitrust violations that are happening, where there's a complete inequity of power between us and people that tell us that we have to hand over our rights in those situations?
Oh, yeah, the antitrust laws need to be expanded. You've got Google, you've got Facebook, you've got Amazon. There's a law student graduated from Yale last year, Lena Khan, who's written a law review article saying that the Facebook, the Silicon Valley world, has got to be enveloped in a new kind of antitrust law.
Coming to the forum in the spring.
and she's coming to the forum. There's an example, you see. I mean, I wrote my third-year paper, as Pete said, on unsafe automobiles and legal liability. It took a long time to get the evidence and all, but it turned it into unsafe and e-speed. I don't know whether you're required to do third-year papers. Are they optional? Are you required? Optional. Do a third-year paper that may spearhead your whole career. That's going to spearhead her whole career. She's now part of a group of 12 people in Washington, D.C., like a public interest law and economics think tank, and she's also got some sort of teaching thing at Yale Law School. So you want to do it before you get compromised, before opportunity costs get too irresistible. You want to try to do a third-year paper. Tons of great groundbreaking material in all these areas that I mentioned that you can mention as well. On the public commons, David Bollier, who is in Amherst, he's the national expert on it. It's David Bollier, I think, .org, B-O-L-L-I-E-R. He's very happy to come to the law school. Yeah. He's connecting internationally with this whole commons movement, and it's intellectual commons as well. It's a mind-blowing door opener for getting the wealth of the people, owned by the people, to be controlled more by the people before they actually strip the commons legally from public ownership, as they want to do with the public lands.
Let's do one more question over here. And if you want to get started on your throughout paper, write an article for the record to get you started.
Thanks so much for coming today. So knowing what we know today about what exactly a year ago happened, what was then and what is your opinion now of both Jill Stein and Gary Johnson's run for?
Of what? I didn't quite.
What is your opinion of both Jill Stein and Gary Johnson and their bid for the presidency in 2016?
Oh, well, I'm all for more voices and choices. Why should we have a two-party duopoly that rigs the ballot access laws and other laws against the freedom of speech known as running for office on third-party and independent candidates? I mean, it's amazing how when I ran in 2000, Professor Dershowitz called my Green Party campaign anti-democratic. I mean, he said some crazy things in his career. I mean, you want to give another choice on the ballot to the American voter and it's anti-democratic? It's like the two parties own the voters. So and by the way, a very good article appeared in the Harvard Journal of Legislation about 10 years ago on reforming the state ballot access laws. Let's have some more?
One more question. We have time for one more.
We got some more.
Right back there.
You ready to speak up? Hi, thank you for coming. I'm at 2L, and something we hear a lot is that it's good to go to big law firms because you get the best training. I'm guessing you don't agree with that. I'm hoping at least. Where would you recommend for those of us who are still in law school, where do we get good training besides big law firms?
Well, first of all, that is a myth to discourage you from going into public interest law, because it deals with justice, normative stuff, squishy, soft stuff. When you go to a major law firm, you're going to be very specialized very fast. That's negative number one. Very few law firms will rotate you. You get very specialized and you're clinging to a senior partner who relies on your expertise and keeping up to date and doesn't want to diversify you. Number one. Number two, look what you're working on. Very, very micro issues in taxation, securities exchange. So it may make you sharp by making you narrow. That's a price to pay, isn't it? And the third, it doesn't expand your ability to take your conscience to work, which is the engine for broader-based intellectual application for justice. See, it's not just your LSAT score, right? If you're allowed to take your conscience to work, you start asking questions, you start probing, you start elaborating your own curiosity in much more rigorous fashion than if you're very specialized. And by the way, once you get specialized and you don't make partner, where are you going to go? You're not assailable anymore if there isn't a job in that area of specialization.
Other questions?
election made the country better off?
Of course it did. And the fact that you're implying that somehow they were spoilers indicates how much of a conceptual prisoner you are of the two-party duopoly, if I read your inference right. For example, let's take 2000. There's no such thing as a spoiler unless we're all spoilers of one another trying to get votes from the American people. A spoiler is a derogatory slur. It's a politically bigoted word that's only applied to outsiders who are trying to challenge the corrupt, corporate, financed political system. And so once you say we all have an equal right to run for election, we have an equal right to get as many votes as possible, either we're all spoilers of one another or none of us are spoilers. And when you have a spoiler mentality, maybe I'm inferring too much in your question. When you have a spoiler mentality, what happens is you forget about other facts, like 250,000 Democrats voted for George Bush in Florida, 250,000. The theft of the ballot shenanigans in Florida, the fact that Gore won the popular vote. The Greens are responsible for the Electoral College. They're responsible for Scalia and 5-4 judicial coup d'etat. You see, it gets you into a crazy situation that we shouldn't get into if we believe in equal right to run and equal right to get votes from all the people. I happen to think that our agenda was a majoritarian agenda. If you polled full Medicare for all, living wage, cracking down on corporate crime, civil liberty revision of the Patriot Act, on privacy, etc., it's a majoritarian agenda. I've kept my website open, votenader.org, from 2008, so you can see the agenda. So it's not just a bunch of people just coming to Earth from UFOs with some crackpot ideas. The two major parties represent often minority popular positions in terms of public opinion polls.
Other questions? We are at 12:58, so got time.
Thank you for coming here and hearing from you. It's an honor. What do you think most effectively deter corporate misconduct? Because it seems to me, after all these years, corporate misconduct is still on the rise. And if individual commits crime, they go to jail. But if corporate commits a crime, they pay fine. And it seems to be there are two systems of justice in the same country.
No, exactly. Yeah, the too big to fail, too big to jail, yeah, exactly. That's a long answer, right? We have to start with sensitizing the public that they cannot live in a society where corporations as an entity have equal rights under the Constitution, called corporate personhood. So first, you have to say the Constitution's never mentioned the word corporation or company. Why do they rule us? Well, there's a history of judicial decision on that, which is 1886. So we need there are two ways to get elbow room here. Subordination of the corporate entity to the sovereignty of the people. The Constitution starts we the people, not we the corporation or we the Congress. Subordination in all different ways. So the corporate entity cannot legally lobby, cannot legally give money to campaigns, cannot legally do all the things they can legally do now because they've been given all the constitutional rights of real people, even though they're artificial entities. That means everybody in the corporation can do lobby, but not the corporate entity. The second is I call displacement. You have local economies that displace the sales, like credit unions, community banks, local renewable energy, community health clinics with emphasis on prevention, farmer to consumer marketplace. All these drain away sales from the absentee multinational corporations with their agents and their dealers. And so that begins to develop an alternative economy, which is tens of billions of dollars now. And it's a very significant one. But you want to shop Amazon, or do you want to shop your local hardware store? You want to get everything online, coming to you with drones, and Main Street is empty. the main street that paid property taxes for your children's schools. You have to decide. Do you want to shop with a corporate criminal Wells Fargo, or do you want to shop with your credit union or your local community bank? Do you want to buy from ExxonMobil, or do you want to have local wind power and housing-sited solar panels? So those are the two. Besides that, we need to make it a political issue and beef up the corporate crime prosecution budget of the Justice Department, the SEC, etc. We need to completely reevaluate the charter. The charter is ancient, it's too permissive, and we have to rewrite the corporate charters for greater disclosure, greater investor rights, pension funds, for example, greater rights for workers, etc. Now, all this has been worked on. If you go to nader.org, you get my column free every week, 7 minutes of agitation. And you'll get references. We have an empowerment program addressing your question right there.
Thank you for that. Ralph, one announcement for the forum. Tomorrow we have the case for Medicare for All with Tim Faust. He runs Heavy Medical. A final word you have?
Yeah, final word is read the record, work with the record, volunteer for the record, write for the record. Record is raising the big, big questions. And I'll leave you with the leading ethics professor in the United States, Stephen Gillers at NYU. And here's his words in a fantastic article called, "Is Law Still an Honorable Profession?" That's Gillers. Every law student really should read this speech that he gave before a Jewish synagogue. He said, quote, "A lawyer who uses his or her legal education and skills to distort the law, to destroy the rule of law, because he or she is adept at manipulating language and no judge, no adversary is watching, is as blameworthy as the client." End quote. Raise the level of your significance to your true potential, which is massive and can be wildly successful beyond your greatest dreams. I offer you a whole series of Harvard Law grads who've accomplished that goal, but they're a tiny, tiny fraction of 1%. Thank you.
You can do that too. Thank you, Mr. Ralph Nader. Thanks, everyone.